Welcome back. I've been working through this week's batch of scripts, and one of them kept pulling me back. It's about a woman named Mara, a country estate, and a piece of paper she signed in the worst week of her life. Most stories about inheritance are about greed. This one is about something quieter and more precise. Watch for the moment she stops reacting and starts reading. You're watching Eternal Diary. The smell of the house hit me before I even reached the front steps. Old wood, lavender, and something underneath that. An astringent, medicinal undertone that I associated with hospital rooms and defeat. Thornfield had smelled like this before, when my grandfather died. That was 16 years ago. I was 12 then, standing in this same spot in front of these same wide stone steps, understanding for the first time that things end. I stood there now for a moment longer than I needed to. My bag was still in the car. The drive up from the city had taken just over 3 hours, most of it motorway. The last 40 minutes through country roads that narrowed and darkened as they went. Callum had texted me the day before. Grand's had a turn. Come if you can. I'd been in the middle of a quarterly review at work and had still driven home. Asta packed a bag and left before the review finished. That was the kind of person I was when it came to Margaret. I don't think I need to explain that to anyone who had a grandmother like mine. I picked up my bag and went inside. The entry hall was cool and dim, the way it always was in late autumn. Margaret had never been a woman who needed rooms to perform grandeur. The house was substantial. 4 floors, 11 bedrooms, a library, a garden that backed onto farmland she'd owned for decades. But she had always used it like a home rather than a statement. The furniture was comfortable. The rugs were worn in the places where people actually walked. There were photographs everywhere, arranged without system, the way you arrange things when you're not performing for anyone. I noticed Callum's overnight bag by the staircase before I noticed Callum. He came out of the kitchen holding a mug, and he smiled in that way he'd been smiling at me for years. Warm on the surface and just slightly too careful underneath. My brother was 4 years older than me, and he had always made me feel the gap. Not cruelly, not all the time, just consistently enough that I'd grown up understanding the shape of his regard. "You made good time," he said. "How is she?" He tilted his head toward the stairs. "Better than yesterday. She wanted to see you." I went upstairs without asking anything else. Margaret was propped up in the bed she'd shared with my grandfather until the day he died, in the room at the end of the corridor with its own fireplace. The fire was lit. She looked smaller than she had in the summer, which had been the last time I'd seen her. She had never been a large woman, but now she looked as though the bed was keeping her anchored rather than simply supporting her. She turned her head when I came in, and her face did something complicated. "Mara," she said. I sat on the edge of the bed and took her hand. It was warm and dry and felt lighter than I remembered. We talked for nearly 2 hours that first evening, about ordinary things, the way you do when the thing you're actually talking about is impossible to say out loud. She asked about my work, my flat, whether I'd finally had the leak above my kitchen window repaired. I told her I had. She said she didn't believe me. She was right. I hadn't. She fell asleep mid-sentence, which the nurse, a quiet, efficient woman named Carla, told me was normal. I went back downstairs. Arabella was there. She was Callum's wife of 7 years, and she had the particular quality of a person who has already had a conversation about you before you walked into the room. She was standing near the kitchen table with a glass of wine, and she greeted me with an embrace that lasted exactly long enough to look genuine. "We're so glad you could come," she said. I wasn't sure why that phrasing bothered me. I'd think about it later. Dinner was Arabella's cooking, a slow braised thing with bread and a green salad, the kind of meal that takes several hours to prepare and signals that someone had been expecting this evening for longer than the day's urgency implied. Callum poured wine. They talked about Thornfield, about the garden, about a fence repair on the northern boundary that had apparently been necessary for some time. They did not mention the estate. They did not mention the word solicitor. They did not mention anything that would tell me what they'd been doing in the house before I arrived. I ate. I listened. I filed things away. The house had a rhythmic quality during the days that followed. Mornings, Carla's schedule, the medications, the careful management of light and temperature. Afternoons, Margaret sleeping, the 3 of us navigating each other across the rooms. Evenings, a kind of enforced domesticity, dinner on the table, the fireplace lit, The television sometimes on in the background at a volume that discouraged real conversation. I slept badly from the first night. That's worth noting, not as a complaint, but as a fact. The guest room I'd always used had a window that faced the back garden. And there was a noise I couldn't identify. Something in the eaves, or the heating, or possibly the wind finding a specific gap in the tiles. I mentioned it to Callum. He said he hadn't noticed anything. By the third night, I was running on fragments. An hour here, 90 minutes there. My body was present in the house, but my mind had that blurred, slightly underwater quality that comes with accumulated exhaustion. The world still made sense, but slowly. Decisions felt heavier than they should. I didn't recognize this at the time as something being done to me. That's the thing about conditions that are created gradually. Each element is plausible on its own. The noise in the eaves is just a noise. The late evenings that extended past midnight are just grief doing what grief does. And just the kitchen that always had food and wine and good conversation was just hospitality. None of it announces itself as a system. My access to Margaret was managed. I understood this with full clarity only in retrospect. At the time, it had the texture of logistics. She was tired in the mornings. Carla had specific windows when visits were encouraged. Callum had usually been in with her already when I came up, and sometimes he was still there, sitting in the low chair beside her bed, and the conversation would be the three of us, rather than the two of us she and I had always preferred. When I did get time alone with her, it was brief. 20 minutes, sometimes 30. She was tired quickly. Callum would appear at the door, just checking, he'd say, and the shape of the visit would change. I noticed this. I told myself I was being uncharitable. On day 4, Margaret asked me, while Callum was briefly out of the room, whether I'd spoken to anyone about the papers. I said, "What? Papers?" She looked at me for a moment. Something crossed her face that I could not read. "Callum said he'd explained," she said. "He hasn't explained anything to me yet," I said. She reached for my hand. She held it for a long moment. Then Callum came back in, and the conversation went somewhere else, and by the time it had gone there, Margaret was tired, and it was time to let her rest. I replayed that exchange for the rest of the day. She had expected me to know about papers. Callum had told her he'd explained, he had not explained. The gap between what Margaret thought was happening and what was actually happening was not a misunderstanding. It was a managed condition. I tried to get time alone with her again that evening. Callum said she'd already had a busy afternoon, and he thought it better to let her sleep. He said it gently. He said it with his hand briefly on my shoulder, the way an older brother comforts a younger sister who is being overprotective and needs to be guided toward reasonableness. I went back to my room. I sat by the window with the noise in the eaves, and I tried to call a friend from the city, someone entirely outside this house and this family and this situation. I got 2 bars of signal, the call connected, and then dropped after 30 seconds. I tried again. The same. The area had always had poor coverage. That wasn't new, but I noticed it that night in a way I hadn't on previous visits. On the 5th evening, Callum sat down with me after dinner with a folder in his hand. He'd poured wine for both of us, which he placed on the table with the particular deliberateness of someone who had thought about this conversation in advance. The folder was manila, standard, nothing about it designed to announce itself. "Gran asked me to take care of some things while she's still lucid," he said. "She's thought it through. She wants to make sure everything is in order." I asked what kind of things. He said it was mainly property reorganization. A solicitor was coming on Thursday, the day after tomorrow. It was primarily administrative, he said. Gran wanted to avoid probate complications, he said. He said the word probate as though it were a thing to be avoided the way you avoid a difficult neighbor. Not dangerous, just unpleasant and time-consuming. I asked to see the folder. He said he needed to go through it with the solicitor first to make sure he fully understood the details, and then he would walk me through everything properly. He smiled. He picked up his wine. He went to bed. I sat at the kitchen table with the noise carrying through the walls and the wine untouched in front of me. The solicitor who came on Thursday was named Prosper. I learned this from Arabella, who mentioned it over breakfast, as though confirming something I already knew. Prosper Haverstock. She said the firm name with a specific kind of familiarity, the way you name a dentist you've been going to for years. Not Callum's firm, she said. He'd worked with Gran for a long time. I searched the firm on my phone. Poor signal. I got a partial result. The firm's name in a directory listing. and then lost the connection before it loaded fully. He arrived mid-morning, a neat, compact man in his late 50s with the particular manner of someone who has spent a career managing difficult conversations for families in distress. He shook my hand when Callum introduced us. He said he was so sorry about Mrs. Thornfield. He used that name for her, more formal than anything I'd ever heard her called, and that it was good to finally meet me. The word finally implied a prior familiarity with my existence that made me feel briefly like I'd already been discussed. Prosper spent the first 40 minutes alone with Callum in my grandmother's study. I was in the garden, ostensibly because the day was clear and the air was better than the house's recirculated warmth. But in reality, because Arabella had suggested, not quite directly, with the gentle efficiency she brought to everything, that it might be better to let Callum go through the preliminary paperwork first, and then I could ask questions. I don't know why I agreed to that. I think, if I'm honest, it's because the sleep deprivation and the grief and the distance from my ordinary life had made me feel like the ground was slightly unreliable. And when the ground is unreliable, you accept the paths people offer you. That's what no one tells you about sustained vulnerability. It doesn't feel dramatic. It feels like being too tired to argue, and too sad to insist, and too uncertain to know whether your suspicion is legitimate or whether you're just exhausted and making something out of nothing. When Prosper came to find me in the garden, then he was carrying a cup of tea he'd made himself in the kitchen. He sat in the other garden chair, and he explained in patient, measured language that Margaret wished to reorganize certain aspects of her estate while she was still in a position to do so, that there were tax efficiencies to be achieved, that the primary asset under discussion was Thornfield itself, the house and its surrounding 2 acres, and that Margaret wanted the title transfer to be documented cleanly while she remained capable of expressing her wishes, which would simplify administration when the time came. He used the phrase "when the time came" 3 times in 7 minutes. I asked what exactly was being proposed. He explained that the plan was for my grandmother to make a lifetime gift of Thornfield to Callum, who would hold it as sole owner. So yes, this was Margaret's express wish, he said, because Callum was locally situated and in the best position to maintain the property. The rest of the estate, the investment portfolio, and the cash assets would be distributed equally among her beneficiaries upon her death, in accordance with the existing will. I asked what Thornfield was currently worth. He said the last formal valuation had placed it at approximately $2.3 million. I asked what the investment portfolio was worth. He said those figures were part of the estate documentation, and he would need to arrange for me to see them in due course. I noted that he hadn't answered the question. He said he appreciated my diligence. That night, I lay in the guest room and tried to do arithmetic. My grandmother's estate had always been substantial, in the general way that family members understand things they haven't been explicitly told. She had inherited Thornfield from her own parents, had maintained it competently for 50 years through good management and careful decisions, and had accumulated investment assets in the later part of her life through habits of saving that she described as boring, and that had apparently been effective. If Thornfield was worth $2.3 million, and if the investment portfolio was, say, $400,000, a conservative estimate, then the total estate was somewhere around $2.7 million. Per the existing will, I was entitled to 30%. That was approximately $800 to $10,000. If Thornfield was transferred as a lifetime gift before the estate was settled, then the value being distributed at death was only the portfolio and the cash. Callum would receive Thornfield in its entirety, $2.3 million, plus his share of the remaining assets. That was not an administrative efficiency. That was a redistribution of almost the entire estate to one beneficiary before the estate could be contested. I stared at the ceiling of the guest room with the unidentifiable noise in the eaves, running this arithmetic 3 different ways to make sure I wasn't misunderstanding it. I wasn't misunderstanding it. I called Callum's number. It went to voicemail. I didn't leave a message. I got to see Margaret alone the next morning for 20 minutes. She was more alert than she'd been. The nurse said these windows could be temporary and could also be a sign of something less encouraging. I sat on the edge of her bed and held her hand, and we talked, and she was coherent and wry and almost herself. She asked after a friend of mine she'd always liked, a woman I'd known since university, someone Margaret had met at my graduation and remembered with an exactness that always moved me. I told her the friend had just had a second child. She smiled. I wanted to ask about the papers, about Prosper, about whether Callum had accurately described what she wanted. The questions were right there, already formed. I didn't ask them. She was tired after 20 minutes, and her eyes were doing the particular thing they did when she was trying to stay present and it was costing her effort. I said I'd come back in the afternoon. I squeezed her hand and stood to go. In the corridor, Arabella was waiting. She had another cup of tea. She handed it to me with a look of such practiced sympathy that I felt something shift quietly inside me. A small, precise recalibration, like a scope being adjusted. "It's hard, isn't it?" she said. "Yes." "Callum is only trying to do what Gran wants," she said. "All of this is so she can be at peace. You know that, don't you?" It was almost a question. Almost. "I know," I said. I took the tea. I walked back to my room. I poured it down the bathroom sink. The document came on a Saturday. By then, I had not slept more than 4 interrupted hours on any single night for 9 days. My phone had 26 unread work messages I hadn't had the bandwidth to respond to. I had been eating irregularly. Arabella's food was on the table every evening, substantial and well prepared. But I kept arriving at evening, having missed the hours in between. I know, in retrospect, precisely what that combination does to a person's cognitive function and decision-making capacity. Sleep deprivation alone impairs judgment at a level comparable to moderate alcohol intoxication. Add acute grief, social isolation, and sustained low-level pressure from the people you're isolated with, and you have a person whose defenses are not gone but are significantly degraded. That degradation was not an accident. Callum brought the papers to me in the sitting room off the main hall on a Saturday at 2 in the afternoon, when Margaret had just gone to sleep and the house was quiet. Prosper was present. There was also a woman I didn't know, introduced as a witness from Prosper's firm. Oh, a neat woman in her 40s who set her bag beside the chair and produced a pen from it without making eye contact with me. The document was 11 pages. Prosper talked me through it standing, holding his own copy, walking me through what he described as the main points. He used the phrase estate efficiency 4 times. He described the document as confirming my understanding and agreement, as a named beneficiary, that Margaret wished to make this lifetime disposition. He called it a family consent and acknowledgement. He did not call it what it was, which was a deed of renunciation. I said I'd like to read it myself. There was a brief silence, the kind of silence that has a texture. Then Prosper said, "Of course, absolutely. Take all the time I needed." And then Callum said, "Gran was asking after you this morning. Oh, she said she wants to know this is settled before she goes to sleep tonight." I looked at him. He looked back at me. His expression was soft, concerned, the face of someone delivering a message they wish they didn't have to deliver. I read the document, or I tried to. The language was dense in the specific way that legal documents are dense when someone wants them to be difficult to read quickly. Technical vocabulary embedded in long subordinate clauses. Key provisions distributed across multiple pages so that no single section showed the whole picture. Cross-references to a Schedule A that was at the back, separated from the main text by a page break, and what looked like supplementary definitions. I got through most of it. I moved slowly. I identified several things that seemed significant and flagged them in my mind. Well, I asked about a clause on page 7, a provision relating to the interaction between the lifetime gift and the existing testamentary dispositions. Prosper explained it. His explanation was accurate in its narrowest technical reading and functionally misleading in its practical effect, though I would not understand that fully until I was back in my own kitchen, at my own table, without anyone in the room. I asked if I should have my own solicitor review this before I signed. Prosper said that was entirely my right, of course, but that engaging independent counsel might take several weeks, given availability at this time of year and given Mrs. Thornfield's current condition. He let that sentence end there. He didn't finish it. He didn't need to. I looked at the document. I looked at Callum. His face was exactly what it had been since I walked into the room. Warm, careful, arranged. I signed. I signed all 11 pages where the tabs indicated, and I watched the witness countersign beside my name. And I watched Prosper collect the pages and align them with the precision of someone who has done this before. And Callum's expression did not change. That was what I would remember. He didn't look relieved. He didn't exhale. He didn't offer any sign that what had just happened mattered to him. His face was exactly what it had been before I signed, which meant it had been prepared in advance for after. Margaret died on a Tuesday, 9 days after I arrived. It was early morning, pale, thin light coming through the gap in the curtains, the fire gone low overnight. Carla was there, and I was there. Oh, and it was quiet in the particular way that rooms go quiet when something irreversible has just happened. I sat with her for a long time afterward. The room still smelled of the lavender she'd kept in a drawer beside her bed for as long as I could remember. I held her hand after she was gone, the way you do when you're not ready to let the gesture be something it isn't yet. Then I went downstairs, made a cup of tea I didn't drink, and sat alone in the kitchen. When Callum came down, he put his arm around me briefly and said he'd start making calls. He was efficient about it. He had his phone out within minutes. Arabella appeared an hour later in a different register. Not visibly different. Not crass, not triumphant. But there was an organizational energy about her that felt like it belonged to a later stage of grief than the one I was in. She began talking about the caterers for the funeral almost immediately. She had a short list. She had already thought about the flower arrangements, whether to use the local florist or someone from the city. I noticed this. I said nothing. I filed it. The funeral was 8 days later. The people you'd expect attended. Neighbors from across the valley, old friends from Margaret's earlier life, her book club, distant relatives who drove long distances and ate sandwiches in the hall and said she'd had a good long life, which was true, and was also the kind of thing people say when they don't know what else to say. I stood at the front with Callum and Arabella and received condolences and said the right things and watched people I'd known since childhood embrace my brother and tell him what a good grandson he'd been to her, and how she'd spoken of him with such pride. She had spoken of me with such pride too. I understood that this was not that kind of room. In the car on the way back from the church, Arabella said she'd been in touch with an architect. She said it casually, conversationally, the way you mention something you assume the other person already knows about. Some ideas for the East Wing, she said. Nothing definite yet. I looked out the window at the hedgerows going past. I made a note on my phone, in the memo I'd been quietly building since the third night at the house. The note said, "Architect mentioned day of funeral." I drove back to the city 2 days after the funeral. I had Callum's assurances that Prosper would be in touch about the estate administration in due course. I had a vague, constructed sense that things were in hand and that my role was to wait. I had also, in the last 10 minutes before I loaded my bag into the car, done something that had seemed instinctive in the moment. I had gone back to the sitting room where the signing had taken place, retrieved the copy of the document that had been left on the sideboard. I noticed they'd left it there rather than putting it away, which, in retrospect, seemed like either carelessness or a certain assumption about whether I'd take it. And I had photographed every page on my phone. All 11, including Schedule A. I drove 3 hours back to the city and unpacked my bag and answered the 26 work messages and slept for 11 hours. And then, on the 4th evening home, I sat down at my kitchen table with a glass of water and opened the photographs. I read the document again, slowly this time, in my own space, without exhaustion, without Callum in the room, without Prosper's measured voice occupying the silences before my thoughts could form. What I had signed was not a family consent and acknowledgement. It was not a confirmation that I understood my grandmother's wishes. It was, in the specific legal sense that I would come to understand thoroughly over the following weeks, a deed of renunciation of beneficial interest. Schedule A, the section at the back, the one Prosper had described briefly and without emphasis, reorganized the estate plan such that my 30% share as a named beneficiary under the existing will was to be absorbed into the Thornfield title transfer. The lifetime gift of Thornfield to Callum was not separate from my inheritance. It was paid for, in part, by my inheritance. My 30% of the estate was, at the valuations I could calculate from the document, somewhere between $780,000 and $840,000, depending on how the portfolio was assessed. I had signed it away in 11 pages. I'd been actively discouraged from reading at my own pace. I sat with that for a while. Then I opened a new browser tab and started searching. Here is what I learned in that first night and in the days that followed, And I'm going to be precise about it because this is the part of this story that is useful beyond my own situation. Undue influence is a legal doctrine that applies when a person's free exercise of judgment has been overridden by the pressure, manipulation, or coercion of another. It is not the same as fraud, though it can accompany fraud. As it is not the same as incapacity, the person influenced does not need to have lacked mental competence. What matters is whether their choice was genuinely free. In estate and probate law, undue influence can be applied to lifetime gifts, deeds of gift, renunciations of beneficial interest, variations of will, and other dispositions of property made during or shortly before death. It is one of the most commonly invoked grounds for challenging estate transactions, and it is more frequently successful than most people assume precisely because of the circumstances in which estate decisions are typically made. The legal framework for proving undue influence has 4 elements, consistently applied across the case law. The first is vulnerability. The person influenced must have been in a state of susceptibility through illness, acute grief, physical exhaustion, dependency on the influencing party, or any combination of those. The vulnerability does not need to be permanent or clinical. Situational vulnerability is sufficient. Sleep deprivation across multiple consecutive nights impairs executive function and impulse control. Acute grief disrupts the capacity for strategic thinking. Being the only person in a remote house who does not know what the others know for an extended period creates a specific kind of cognitive isolation. All of these are recognized in the case law. The second element is opportunity. The influencing party must have had consistent access and the practical ability to exert pressure over time, not a single coercive moment, a pattern of conduct, a campaign, control of information flow, control of access to other people, via control of the environment in which the decision is eventually made. These are all forms of opportunity. The third element is disposition. There must be evidence that the influencing party had a motive to secure an outcome they would not otherwise have been entitled to, and that they took steps consistent with that motive. This is usually inferred from conduct before and after the act. What were they doing before the signing? What did they do immediately after? The fourth element is causation. The transaction, the signing, the gift, the renunciation, must appear to be the product of the influence, rather than the free, informed choice of the person who signed. Critically, courts look at whether the person was advised of their right to seek independent legal advice, whether that advice was proactively offered and encouraged, and whether any attempt to obtain such advice was deflected or discouraged. I found a senior court case from several years prior in which the judge had set out these elements with particular clarity, and I read that judgment 3 times. I printed it. Then I opened my email and searched for every message Callum had sent me in the preceding 3 months. I found 11 that were relevant. Individually, each was subtle. Together, they had a pattern that was specific enough to see. The first relevant email was from 2 months before I arrived. Callum had written to say that Margaret was managing well, but had had some concerning moments, and that he'd been spending more time at Thornfield to keep an eye on things. He mentioned in the last line that he'd been thinking about the long-term future of the house. At the time I'd read that as exactly what it appeared to be, a caring grandson thinking about logistics. In the context of everything else, it was something he was establishing, that he was the person in Margaret's life, and I was at a distance. The second email was a month later. He mentioned, in passing, that he'd spoken to a solicitor about estate planning in general terms, just to understand what options were available. He said he thought it was the responsible thing to do, given Gran's age, and asked if I had any thoughts. I had replied with something vague and supportive. That email established his groundwork with me, that he was taking initiative in a responsible way, and that I'd been given an opportunity to engage and had deferred. The third and fourth emails were in the weeks before my arrival. Both referenced Gran's wishes in general terms. Both used the phrase, what Gran would want. None of them mentioned Prosper by name. None of them mentioned a renunciation. But the architecture was there, each email slightly building the expectation that Callum was handling things, that Gran had wishes, and that my role was to be supportive of whatever had been arranged. I created a folder on my laptop. I called it, plainly, documentation. I began to build it methodically. Every text from Callum screenshotted and dated. Every email saved as a PDF with the full header information preserved. The photographs of the 11-page document, organized by page number, the photographs of Schedule A, separately labeled and notated. I wrote in a separate document a precise timeline, each event in order with its source and its significance. And I noted the dates, the sequence, the gaps where information should have existed and didn't. I noted the phone call I'd made to Callum the night the arithmetic didn't add up, the call he hadn't answered. The date and time were in my phone records. I noted Arabella's comment in the corridor before I'd asked a single question about the document. Callum is only trying to do what Gran wants. A preemptive reassurance is not the same as a reassurance. A preemptive reassurance is evidence that someone knows there is something to be reassured about. I noted the architect comment in the funeral car. I noted the fact that when I had asked about getting my own solicitor to review the document, Prosper had said it was my right before allowing Callum to redirect the conversation using Margaret's condition as the deflecting mechanism. I noted that Prosper's client relationship appeared to be with Callum rather than with the estate, based on the pattern of their interactions. Who was present at every meeting, who had the folder, who had clearly already reviewed the document before I was shown it. I spent 5 days building the folder. At the end of it, the folder contained 47 files. Then I went back to my notes on the legal framework and I mapped my evidence against each element. Vulnerability, documented through the circumstances. Sleep deprivation across 9 days. Acute grief, limited signal, limited contact with anyone outside the house. Financial information deliberately withheld. Opportunity, Callum's control of my access to Margaret, his management of the information I received, his coordination of Prosper's involvement, with the sustained presence across multiple days rather than a single interaction. Disposition, the pre-arrival emails establishing his role as administrator. The document itself, prepared before my arrival. Arabella's preemptive reassurance. The architect consultation, which I now suspected had been scheduled with an assumed outcome. Causation, the request for independent legal advice that had been deflected using emotional leverage about Margaret's comfort. The description of the document as administrative when it was material. The distribution of key provisions across the document in a way that obscured the complete picture. I looked at the 4 columns for a long time. Then I asked 2 colleagues if they knew an estate solicitor for complicated matters. One of them paused before answering, and then gave me a second name instead of the first one she'd thought of. The second name, she said, was better for complicated. His name was Gideon. I called his office on a Thursday morning. His assistant scheduled a consultation for the following Tuesday and described the fee structure without apology, which told me something about both the firm and the clientele. I spent the weekend before the meeting organizing the 47 files into a coherent briefing. I created a printed timeline, each event, its date, its source, its significance. I wrote a separate page calculating the financial impact of the renunciation 3 different ways to account for different assumptions about the portfolio valuation. I printed the 11-page deed and annotated the relevant clauses and their interaction with Schedule A. And I made a separate sheet that mapped the 4 elements of the undue influence framework and noted against each one what evidence I had and what evidence I might be able to obtain. When I arrived at Gideon's office on Tuesday, a 3rd-floor room in a building that was functional rather than impressive, which I took as a good sign, I put the briefing on his desk. He said he'd need some time to look through it. I said I'd wait. He read for 22 minutes. He made notes twice. At some point, he turned back to the timeline and read it a second time. He was unhurried in the way that people with good judgment tend to be unhurried. Not slow, but not performing speed either. Then he looked up. "You didn't have independent legal advice before signing," he said. "Oh, no. And Prosper's client was effectively your brother. The engagement was described as acting for the estate, but every decision about timing and presentation appeared to go through Callum. The clause on page 7. He had the document open to it. You asked about this at the signing. I did. And his explanation was accurate in its narrowest reading. It didn't address the interaction with Schedule A." He looked at me for a moment. "The interaction with Schedule A is where your 30% went." "Yes." He put the papers down. He picked up his pen, didn't write anything, set it at a specific angle on the desk. He had the particular manner of a person who has formed an opinion and is deciding how much of it to share. "What you've described," he said, "is an undue influence campaign. It's structured rather than opportunistic, which is actually more provable because structured campaigns leave more evidence. The vulnerability is well documented given the circumstances. The opportunity is evidenced through the communications and the pattern of access management. The disposition is in the emails and the conduct post-signing. The causation is the strongest element because you explicitly invoked your right to independent advice, and that invocation was deflected using your emotional state." He paused. "There's also a potential professional negligence claim against Prosper's firm. A solicitor overseeing the execution of a document in which a beneficiary renounces a significant financial entitlement has a duty of care to that beneficiary. Failing to proactively advise you of your right to independent counsel, and then allowing that right to be redirected by another party, is a departure from the standard of care." I said, "What are my chances?" He said, "I don't work in percentages. What I'll tell you is that the documentation you've assembled is more complete than most people walk in with after 2 years and a discovery process. You built this in a week." He said we should begin with a letter before action, served simultaneously on Callum, on Arabella as a named party, and on Prosper's firm in its own capacity. The letter would set out the grounds of challenge, the evidence in summary, and would offer a defined period for voluntary resolution. If they were going to settle, this was where it would happen. I asked what we were asking for. He said the full value of the renounced interest plus costs. I asked what happened if they didn't settle. "Oh," he said, "then we file in the probate division." The letter went out on a Friday. I know because I was sitting at my kitchen table when Gideon sent me the copy, and I had opened a bottle of wine I'd been keeping for something specific, and poured a glass I didn't drink. I just needed the gesture of it, the small acknowledgement that the direction of things had changed. Callum called me on Saturday morning from a number I didn't recognize. I noted the number. Then I picked up. He said he'd received a letter from a solicitor claiming to represent me in an estate matter, and he wasn't sure where this was coming from. I said, "You received the letter from my solicitor?" "Yes." He said he was hurt. He said Gran had wanted this. He said the solicitor had clearly filled my head with ideas. I said, "Callum," I read the document. A pause. "Oh, you had time to read it," he said. I did. All 11 pages, including Schedule A. A longer pause. "We should talk," he said, "without lawyers." "The letter explains my position clearly," I said. Then I ended the call. Arabella called that evening. I let it ring. She called again the next morning. I let it ring. She texted at midday. "Mara, I think there has been a misunderstanding, and I'd really like to clear it up if you just give me 5 minutes." I screenshotted the text. I added it to the folder. Prosper's firm responded within 10 days through their own retained solicitor. The response was composed in the particular careful language of people who are not admitting anything but are very aware of their exposure. It indicated that the matter might be amenable to discussion, and made it suggested a without prejudice conversation to explore whether the parties' positions might be reconciled. I instructed Gideon to proceed directly to filing. This is worth explaining because not everyone would have made that choice. Negotiated settlements are faster, cheaper, and less uncertain than litigation. The pull toward resolution is real, and it makes practical sense in many situations. But a settlement offer from a party that is motivated by guilt is not the same as a settlement offer from a party that is motivated by fairness. A guilty negotiation almost never gives you the value of the claim. It gives you the number the other side calculates they can concede without it costing more than proceeding would cost. Even the fact that Prosper's firm moved to discuss within 10 days told me that their own advice had assessed the risk of proceeding as significant. That risk assessment was more useful to me as information than any number they were likely to offer in a without prejudice call. We filed in the probate division of the High Court. Here is what a probate challenge looks like from the inside, because it is nothing like what most people imagine. It is methodical. It is slow in the way that processes with high stakes are slow, because every step has to be done properly, and because properly means thoroughly, and thoroughly takes time. After filing the respondents, Callum was the primary respondent, Arabella named as a party, Prosper's firm joined separately, had a period to file their defense and any counterclaims. So, Callum's defense took 6 weeks to arrive. It was constructed with the help of good counsel, which I'd expected. After the defenses, the parties move into disclosure. Both sides produce the relevant documents in their possession. This is where estate disputes tend to become very interesting. What came out in Callum's disclosure was several things. The first was an email chain between Callum and Prosper that predated my arrival at Thornfield by 12 days. In these emails, which Callum's disclosure team had apparently not understood to be relevant, or had misjudged the significance of, the structure of the renunciation was discussed. The language of the deed was reviewed. There was a discussion about the sequencing of events, how to introduce the document, when to bring it, how to frame the signing meeting. One email from Callum, when sent 11 days before I arrived, included the sentence, "If we can manage the timing right, there shouldn't be any pushback." The second item in disclosure was Arabella's personal calendar, produced as part of the broader estate documentation. On it, for the week of my arrival, there was an entry 2 days after the signing date. It read, "Architect consult, pending paperwork." Pending paperwork. The architect had been scheduled to be consulted 2 days after the signing. It had been scheduled before the signing happened. The third item was not in Callum's disclosure, but came through the estate administrator's files. A handwritten letter from Margaret, addressed to her long-standing personal solicitor. A different firm from Prosper's, a firm in the city she'd used for personal legal matters for over 20 years. And the letter had been written approximately 3 weeks before my arrival. In it, in my grandmother's handwriting, the particular looping, unhurried hand I'd known since I could read, she expressed her wish that the estate be distributed equally among her grandchildren. She wrote that Thornfield should either be sold and its proceeds shared, or held in trust for joint benefit. She wrote that she had spoken to Callum about this, but was not sure he fully understood her intentions, and she wanted to get it down in writing. She had written what she wanted, clearly, unambiguously. 3 weeks before I was asked to sign it away. I want to be honest about what happened when Gideon told me about the letter. We were in his office. He read it to me from a copy on his desk, the same looping handwriting reproduced in the photocopy, and the letter slightly magnified on the page. I did not cry. I sat in the chair across from him, and I felt something very cold and very still move through me. Not collapse, not the thing that breaks you open. The opposite. A contraction, a compression, as though something had been clarified all the way down to its smallest possible form. She had told him. She had told him what she wanted, and he had known, and he had proceeded anyway. I said, "How does this change the case?" Gideon said, "It becomes the center of it." Callum's defense had 3 slippery lines of argument. First, that Margaret had changed her mind between writing the letter and the signing, and that the renunciation reflected her updated wishes. Second, that I had signed voluntarily, having had the document explained and the opportunity to ask questions. Third, that Prosper had discharged his professional obligations appropriately, and that the explanation offered at the signing was sufficient. The defense did not address the email about managing the timing. It offered no documentation of any communication in which Margaret had expressed a changed wish to anyone other than Callum. It offered no explanation for why Arabella's calendar showed the architect appointment as contingent on the paperwork before the paperwork had been signed. The defense also did not address my request for independent legal advice, or the manner in which that request had been redirected. There was a witness. I had not expected there to be a witness. I had hoped for one, in the abstract, in the way you hope for things you can't control. But witnesses are unpredictable, and memories are complicated, and I had built the case without counting on one. Carla, the nurse who had been with Margaret every morning, kept clinical notes. This was her professional practice. She documented every interaction with her patient as a matter of routine. The notes were thorough. In a profession where patients cannot always speak for themselves in retrospect, thorough notes are what stand between care and complaint. During the disclosure process, the estate administrator produced Carla's nursing records, along with the other medical documentation. In the records for the 3rd day of my visit at Thornfield, there was an entry noting that Margaret had asked Carla privately whether Mara had been told about the estate paperwork. Carla had noted that she didn't know, and that Margaret had expressed her wish to speak to Mara about it herself and had asked Carla to arrange time for that conversation. That conversation had not been arranged. Carla's records showed 2 subsequent entries, on day 5 and day 6, noting that Margaret had again asked to see me, and that on both occasions Callum had been present and had said he would pass the message on. I had not received those messages. She had been asking for me. She had been asking for me specifically about the papers, and the person positioned between her and me had said he would pass it on and had not. Carla provided a witness statement. In it, she described these interactions directly and clearly. She described Margaret's manner when she asked about the papers as concerned rather than settled. Oh, she noted that she had not observed Margaret express any wish to proceed with a transfer that her granddaughter was not fully informed about. She also noted, as a trained professional who had worked with elderly patients for many years, that Margaret's physical condition in the days immediately preceding the signing had been consistent with end-stage decline, that she had had increasing difficulty sustaining concentration, that her good hours had been shorter than they'd appeared, and that their appearance of clarity could sometimes be misleading to family members who were not medically trained. Carla had not been in the room when I signed, but her account of what Margaret had been asking for while I was in that house was the clearest possible evidence about what Margaret had actually wanted. As the hearing was before a district judge in the probate division, a woman who had the manner of someone who had heard every version of this particular story and was not inclined to be patient with any of them. Gideon presented the case in 4 focused hours. He was economical. He laid out the timeline, the disclosure documents, the letter in Margaret's handwriting, Carla's witness statement, and the expert opinion he had obtained on the professional obligations of a solicitor overseeing the execution of a beneficiary renunciation. The expert was a retired solicitor with an academic background in estate law, a small and precisely spoken woman who gave her evidence with the confidence of someone who has nothing left to prove to anyone. When she described the professional standard clearly, a solicitor acting in an estate matter who is aware that a beneficiary is being asked to sign away a significant financial entitlement is obliged to ensure that beneficiary has been advised independently and proactively of their right to seek their own legal counsel before signing. That obligation is not dischargeable by offering an explanation of the document. It is not dischargeable by allowing the beneficiary to ask questions. It requires the specific, unambiguous communication. You should consider obtaining independent legal advice before you sign this. Prosper had not said those words. The evidence from the signing, including my own account, which was internally consistent and corroborated by the context, was that no such communication had been made. Callum's counsel argued that I had been a willing, informed participant, that I had asked questions, that I had reviewed the pages, that nothing had prevented me from walking away. The judge looked up from the papers. She asked Callum's counsel, at what point was the beneficiary told that she had the right to obtain her own independent legal advice before signing? There was a pause. Callum's counsel said Prosper had explained the document to the beneficiary in full. The judge said that was not what she had asked. The pause was longer this time. The judgment set out the findings against each element of the framework with precision. Vulnerability was established through the documented circumstances. Sleep deprivation across 9 consecutive nights was a matter of record through the dates and the testimony. Acute grief was evident. Used the physical distance from her ordinary support network, and the poor communications infrastructure of the property had limited her access to independent counsel and outside opinion. These conditions had not been accidental. The email about managing the timing, taken together with the sustained pattern of conduct, established that the conditions had been anticipated and used. Opportunity was established through Callum's consistent control of the environment, the management of access to Margaret, the management of information about the document, the coordination of a solicitor whose practical relationship was with Callum rather than with the estate neutrally. Disposition was established through the pre-arrival emails, the architect appointment, the failure to deliver Margaret's messages requesting to see me, and the conduct immediately following the signing. The shift in Arabella's register, the caterers, the architect discussion in the funeral car. Causation was established through the deflection of my explicit request for independent legal advice. The judge found, on the balance of probabilities, that this deflection, delivered using language calculated to invoke my concern for my grandmother's comfort by a party whose interest in my signing was material, had overcome my free exercise of choice. The deed of renunciation was set aside. It was void ab initio. As a matter of law, it was as if I had never signed it. Prosper's firm had been facing, on a parallel track, a regulatory complaint filed with the Solicitors Regulation Authority. They settled before that process reached its conclusion. Sure, the settlement included a financial payment that covered my legal costs in full, with a sum remaining after. It included a formal admission of a departure from professional standards in relation to the execution of the renunciation. That admission became part of the firm's regulatory record. I will not disclose the precise settlement figure. The estate was redistributed according to the existing will, which had remained valid throughout. The undue influence affected the renunciation, not the underlying testamentary document. Margaret's letter, while not itself a formal testamentary instrument, was consistent with the will and provided important contextual evidence about her intentions that the court noted. My 30% came to approximately $810,000, adjusted for final valuations. Thornfield was placed on the open market. It sold within 3 months, to a family, for slightly above the asking price. Callum received his share of the estate per the will, 25%, which had always been his entitlement. The architect whom Arabella had pre-scheduled, contingent on the paperwork, did not work on the East Wing. I won't tell you I felt triumphant. The word for what I felt was something closer to accurate. As if a set of measurements that had been falsified had been corrected, and the world now corresponded to what it actually was. I called the friend I'd told my grandmother about in her last coherent days. The one with the second child. The one Margaret had remembered with her particular exactness. I said I had something to mark. She asked what. I said I'd explain over dinner. She said, was it complicated? I said it used to be. As there are things I want you to take from this, because this story is not only mine. The mechanism used against me, undue influence over a beneficiary's renunciation, is more common than most people understand. It operates specifically in the conditions that grief creates. The isolation, the exhaustion, the family structure in which one person has been positioned as the natural administrator and everyone else as the recipient of filtered information. The professional introduced by the person with the most to gain, presented as a neutral resource. The protections against it are specific and concrete, and you are entitled to all of them. If you are asked to sign any document relating to an estate, a deed, a renunciation, a family agreement, an acknowledgement, it's a variation of will, while you are grieving and exhausted and alone with the people who benefit from your signature, you have the right to seek independent legal advice before you sign. Not after. Before. The advice must come from a solicitor you have found and engaged yourself, with no connection to any party in the estate. If that right is deflected for any reason, urgency, your elderly relative's comfort, the family's need for harmony, administrative efficiency, that deflection is information. It tells you something about why they do not want you to have the time to think. A solicitor who fails to proactively tell you that you have this right when they know you are a beneficiary being asked to give up a financial entitlement has a professional obligation they are not meeting. That failure is not merely an oversight you have to accept. It is a departure from the standard of care, and it can form part of a legal challenge. Document everything from the moment something feels wrong. Not because you know with certainty you'll need it, because you don't know yet, and the evidence that matters most is the evidence that exists before you understand its evidence. And when someone in your family tells you it's all administrative, and then watches your face when you stop asking questions, that expression, the one that doesn't change because it was prepared in advance, that expression is data. I drove back to Thornfield one last time, several months after everything concluded. The new owners had painted the front door a deep green that I thought Margaret would have liked. Out at the garden had been cleared and replanted, new things growing in the beds where her original plantings had been, the whole space rearranged but recognizably cared for. The house looked like a house, like what it had always been. I sat in my car at the end of the drive for a few minutes. I wasn't waiting for anything. I wasn't processing anything or reaching for anything or completing any particular emotional circuit. I had just wanted to see it once more before it became entirely someone else's story. Then I started the engine and drove back to the city.